Welcome to Sakshi TV special immigration talk show with attorney Mr. Chan Parvathaneni. Please note that Sakshi TV now has 4 immigration shows every week: on Tuesdays with Kaveti, on Wednesdays with Prashanti Reddy in English, on Thursdays with Chan Parvathaneni, and on Fridays with Banu Nindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call us at 8667257441. Before we begin the show, please note that the information provided on this show is not legal advice and for general information purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need any specific legal advice, please contact the attorney directly. Mr. Chan needs no introduction, but if you need consultation, you can definitely log on to their firm, which is svplawfirm.com site. It provides with wealth of free information and online tools in the hand of an immigrant community for which you do not have to be a lawyer to understand. So without any further delay, let's welcome Mr. Parvathaneni on our show. Parvathaneni garu, welcome back, Andy. I hope you're doing well.
Hello, Shivani, and hello all Sakshi TV viewers. Thank you so much. It's good to be back.
Yes, Parvathaneni garu, it's always really amazing to have you on our show every week. So, but before we get on to our actual topic today, can you give a brief introduction about SPP Law Firm and a little about what exactly you personally deal with?
Sure. So our law firm got started in 2012. So since 2012, I've been practicing in Dallas area in this law firm. And I completely focus my time on employment-based immigration. And employment-based immigration is typically, it's immigration law, but for work visas. And for most part, that typically means H1B visa. And also the green cards, the employment-based green cards. So typically, there are 3 categories that Indian nationals mostly use for getting green cards. So most of my time goes into either the green card filings for EB1, EB2, EB3 category or work visas, and that's primarily H1B visas. And I deal a lot with the IT companies. Majority of my practice is with IT companies. And during the course of my career, I've represented the state governments here. We represented the government, the public hospitals. We represented S&P 500 companies and a lot of IT services companies and a lot of product development companies. And that basically means that for most part, it is close to the IT companies, IT services. And the reason for that is IT companies use most of the H1B visas in US. And it's not engineering firms, it's not architectural firms, but it is the IT services companies, the IT product development companies that use majority of the H1s. And what that basically means to me and our law firm is that's my primary practice, working with the IT companies for their immigration filings.
Yeah. So Parvathaneni garu, I am sure you deal with different kinds of, these H1B and especially employment-based, you just mentioned that you work with different IT companies. So can you describe a little, can you go a little deeper in that perspective? Because I'm sure a lot of people come on H1Bs, especially a lot of Indian individuals. So what kind of specific legal, cases that you frequently get?
So the majority of our cases are typically having a foreign national and the need to get a legal way to work in the United States. And in general, most of the non-immigrants in US, if they are students, they start off working in the US on their student status. So they technically get work authorization, and the status is called OPT. Optional practical training, and that's how most of the people who are here in US as students start off their work career. So that is one way of working in US. And the most common way for high-tech jobs is H1B. There are other visas like L1, O, and other visas, but in terms of the number, H1 is where majority of the people work in United States for high-tech jobs. And H1B, this particular class of visa, it's for anybody where the occupation requires a bachelor's degree. And what that means is if somebody wants to work as a mechanical engineer, civil engineer, or as a healthcare administrator, or as a HR manager, any of these professions that in general require a bachelor's degree, they're qualified under a H1B visa. So just because we talk about IT jobs and IT professionals, it is not only meant for IT professionals, it's meant for any profession that's highly specialized. And highly specialized means that occupation requires a bachelor's degree. So any engineering job, any architectural job, any healthcare administration, the high-level healthcare administration jobs, financial analysts, logistical analysts, supply chain managers. So all of these professions are eligible for H1, and we routinely work with other professions. But since it is so famous for IT professionals, and since there is so much of demand for IT professionals in United States, it turns out that it is typically used for IT professions because the big employers, Google, Microsoft, Amazon, these are all IT companies. And because the big employers are IT companies, what has happened is this visa ended up being for IT professions, but routinely we see it being used for multiple professions.
Yes. Okay. That indeed was a great introduction about you and your law firm, Parvathaneni garu. I think now it's time for us to get on to our topic today. But before we get on to this topic, do we have any specific latest immigration updates that we have to know?
Sure. So last month, September, there was a big scare that the government was going to shut down. And that's probably the biggest news in the last 1 week, because if the government did shut down, a lot of immigration-based filings would have had an issue. And so the government shut down. What it means is, if the Congress, if they did not pass their bills, their finance bills, the government does not have money to run. And what that meant is the government would have shut down. And what that means to us in the immigration world is the Department of Labor LCA filings will stop. Department of Labor, the perm labor filings will stop. And that in turn would affect immigration filings, because those offices might not be working, because those departments would have been shut down, more than likely. A lot of these immigration filings would have stopped. And a lot of people panicked, and any cases that people were able to file before September 30th, a lot of companies rushed and filed things like LCAs, things like perm labor filings, and so on. And luckily, there was a little bit of drama last Saturday on Friday, but eventually they came to an agreement, and luckily the government did not shut down. And what that means is things are back to normal and nothing has stopped, because there was a very, very great possibility. It was almost a certain possibility last week that the government would have shut down. And luckily that didn't happen. Things are back to normal. And the shutdowns did happen in the past. And during the previous President Trump's administration, it was shut down once. So government shutdowns keep happening once in a while. We have seen that happen in the past. And we did see an impact with immigration filings whenever this happened. And the good news and the latest news in immigration world this week is none of the filings have to stop. Everything is going smoothly. And there is a deadline. There is a second lottery that happened for the H1B filings. The second lottery deadline is October 31st. And that is something what everybody should keep in mind, that you cannot cross October 31st. If you cross October 31st and you have a lottery selection, it will not be able to be filed unless it is filed before October 31st. So in summary, that's what's going on.
And also, Mr. Parvathaneni, is it true that there would be some major changes, especially in the field of the H1B? Is it actually true, or is it just a rumor that's, circulating across social media?
So it is definitely true that Department of Homeland Security is actively working to change and modernize the H1B program. So it's not just a rumor. So they did take some proactive steps, and they have to follow some procedure before they change any rules. And the very first step is sending their proposal to the OMB department, Office of Management and Budget. So they send their proposal to OMB, and that is the very first step before any rules get changed. And that step has happened in September, last month. And their goal is to have that review done by OMB, and at least they want to target December to publish their proposal. So we know that they're actively working on it. We also know that they are going to be working on modernizing a few things such as amendment filings, things such as the H1B lottery misuse, and things such as the site visits. So this is what they have disclosed. They did not disclose the actual proposal. The proposal is not published yet, but they have indicated, all signs are indicating that the target is December. And by December, we can expect that proposal being published. The rule will not be finalized. It's just the proposal. So the proposal will come out in December. And then there is again a big process. We will have enough time. So the public in US, we can look at it, we can comment on it, and DHS, they will look at our comments. So there is a big procedure that needs to be followed before rules would be changed. And at this point, we know that Department of Homeland Security is seriously considering changes, and they did get the ball rolling, and the process has started.
Yes. Mr. Parvathaneni, what are the new rules that are coming, and is it due to the misuse of the H1B lotteries? Because I think even in our show we did talk about how these frauds were happening, how these multiple lottery selections were happening. So is it is USCIS taking all of this into consideration because of the misuse?
So the H1B lottery misuse is definitely a factor on why DHS is trying to get things changed, but it's not the only reason. They have been trying to make some changes, and even during the last administration, they've tried to modernize the H1B program. They came out with a proposal. It didn't get through all the way. So they did have a few things that they were considering since at least 2020, and the reason being, in 2020, there was a lawsuit, and a few of the old memos, the 2010 Newfield memo, the 2018, there was another USCIS memo, contracts memo. So because of a lawsuit in 2020, this previous memos got rescinded. So ever since then, USCIS was trying to make some rule changes. They're trying to define employer-employee relationship in a better fashion, and they're trying to make some changes to the H1B program because of that. So, and the H1B lottery misuse, I think, also compounded to the problem. So I think they have a number of issues they want to tackle, and they're trying to make some changes. And some of the main changes that they are working on are the lottery, for sure, because the entire lottery program, the way USCIS has designed the process, it is completely inherently has a lot of issues because it is easy for misuse. And that is what has happened. So I think they're trying to fix that problem for sure. That being said, there are also things such as employer-employee relationship. And we had a memo in the past where things were one way, and now we have things one way. So they are also trying to change that part. They're also trying to change some rules about F1. F1, there is something called cap gap. So they want to change rules around cap gap. And there are also rules that say that when anything changes in the H1B petition, any material change, an amendment needs to be filed. So that is another thing they're trying to tackle. Maybe they're trying to strengthen that rule. Maybe they're trying to put more conditions on when an amendment needs to be filed. And we don't have the final proposal yet, but they have indicated that they're definitely trying to make some changes to clarify on when an amendment is required to be filed. And so these are all a couple of areas I think they're trying to attack. And also another major area is the site visit. So USCIS, all of us know that anytime an H1B is filed, there could be a site visit. So the USCIS officer can come and go to the workplace, and start asking questions. So we have current rules. The current rules are probably not that effective. And USCIS is trying to give more statutory authority to the officers and give more clarity on the site visits. So all of these changes as a whole are being considered. What's finally going to get into the final proposal, we don't know. But these are all the things that they're actively considering to change and modernize.
Yeah. And also, we're hearing that the entire definition of the employer to employee relationship could possibly change. Can you just give us a background history of the employee-employee relationships in the context of the H1Bs, and will changes increase, especially for the H1Bs?
Sure. So in H1B, there is something that is very important called employer-employee relationship. And in general, if the company is sponsoring a H1 and the employee is working from the company's office, it is very clear. It is very easy. The employee is working for the company, for example, Microsoft. Employee will work for Microsoft directly at Microsoft's office. For those kind of scenarios, employer-employee relationship is very clear. However, the H1B visa, it is used by a lot of IT consulting companies, a lot of body shopping companies, a lot of staffing companies. And USCIS in 2010, I think they saw that as a problem. And what they did is they came back and said, anytime you have a company that sponsors a H1B visa, and the employee is going to work at a third party. So, for example, just to give an example, say TCS is applying for a H1B visa, but the employee will not work at TCS office, but the employee will work for TCS's project in Microsoft's office. Third party. So that's a third party. So the company that is sponsoring the H1B, that's a third party because the employee is working at the end client location. And a lot of H1B filings come under that format, third party filings. So third party is the IT services or the consultancy company is filing for the H1, employee is working at a client location. So USCIS, what they did in 2010 is they kind of caused more complexity and added a lot more rules and came up with something called a new field memo. So in 2010, they said that we will deny your H1 unless you're able to prove employer-employee relationship. An employer-employee relationship is a whole list of factors. The employer has to assign the job duties. They have to give their workstations, laptops, instrumentalities. They have to pay them. So there are a whole bunch of factors, not just one factor. But they said they will take a look at the entire set of factors as a whole, and then they will decide if employer-employee relationship is there or not for third-party worksite kind of condition for cases. So anytime any consultancy or a company filed for somebody to work at a third party, the filings all of a sudden became very complex. And we did also see a lot of denials based on employer-employee relationship. And this happened from 2010 until 2020. And in 2020, there was this lawsuit by IT Serve, a very big organization in US. And when this lawsuit happened, the court passed an order against USCIS. And that is when this 2010 old employer-employee relationship memo got rescinded. And after that, because the court said, gave some clarity on that employer-employee relationship, USCIS came up with a new memo. And the new memo said, as long as one of the factors, they gave a bunch of factors, and if one of the factors is met, employer-employee relationship is met. And what that meant is it oversimplified the definition of employer-employee relationship. And right now, USCIS, I think, feels that things are too easy. And I think they're trying to, again, get the old memo back, but by following a proper process. The old memo was issued in 2010 without following proper procedure. So they did not follow the proper Administrative Procedure Act, APA procedures, and which was one of the reasons why they lost in the court. So this time, I think USCIS is trying to go through the process, follow a formal process, and I believe that they're trying to get that old memo back, but by following a proper process and again reactivate it. And I think that's one of the things that's happening right now when they're trying to come up with this new proposal. And this time, clearly, USCIS is following the proper process. So they're going through OMP. They're going to publish the draft proposal. They're going to let the public comment. So they will eventually, I think what's going to happen is they're going to follow the proper process, which means tomorrow it is not easy to be challenged in the court because the old memo was challenged in the court and USCIS, the government, lost in the court because they did not follow the proper Administrative Procedures Act, the APA, properly. This time, to fix the problem, they're going through the act, and we believe the old employer-employee relationship is going to come back again. And that is something that everybody can look for to see what is happening in the next couple of months, because the public has a chance to react. Once these draft proposals are published, people can comment and explain why they feel it's an issue. So what we suggest is wait for the proposal. Once the proposal is published, the public has 30 to 60 days to comment. During the commenting period, make sure your voice is heard by DHS.
Yes. And also, can we get on to the most famous USCIS visits, and also what currently happens, and how, and what kind of changes can one anticipate in during these kind of visits?
So since 2009, uh, USCIS, what they did is Homeland Security, they started a program called Administrative Site Visit Verification Program. So it is a site visit program. Under this, the FDNS officers, the fraud detection officers, what they do is they can come to the employer, the H1B petitioner, or to the employee's work site, and they can start asking a whole bunch of questions to ensure that everything is being complied with. However, FDNS visits happen all the time. They're random and they are to ensure that somebody is complying with the law. However, the current rules say that participation in this program is voluntary. And what that means is the officers don't really have a lot of authority to demand and get some answers. So if the petitioner decides not to participate, the officers for most part have to stop their site visit. And from a USCIS perspective, that's a problem. And in the new proposal, what could happen is they are going to streamline this process. They're going to give more statutory authority to the USCIS officers. They're going to define what they can demand and do more than likely, and make the process more streamlined. Because right now the process is voluntary participation, and things are not. The officers don't have a lot of authority, and that is something what I think we can expect. We don't know what exactly the final rule would be, but they have definitely indicated that there will be changes to the current existing site visit program.
Yes. Mr. Parvathaneni, how long do we, can we wait, or how long do you think it's going to take for these kind of changes to be implemented?
So government has to follow a proper process, and what that means is it's going to take some time, and definitely for the entire proposals to be implemented, even if they speed up things, my guess is it's going to take at least a year. That is because the government wants to be slow, and the reason for that is they want to do the right job, not come up with some random proposals that will be challenged in the court and then get stuck. So the current way is they have the proposal in front of OMB's office, and OMB's office is currently reviewing the proposal. And once the review is done, the final proposals will be published. Current target is December, but it could take more than December. So definitely not before December. And I will not be surprised if it takes longer than December. And once the proposals are published, the process is the local public should be able to review it publicly and put public comments. So everybody will be able to comment and give their comment, whether it's a good proposal, bad proposal, or why they think it will fail, anything. So that is called the comment period. So they have so they have to wait for that comment period to end. And once the comment period ends, they will take a look at the comments, and then they will finalize the rule. They will publish the final rule in Federal Registrar. And once the final rule is published, they will also have to give the implementation timelines. And so we have to see if USCIS wants to target anything earlier, and what kind of an implementation timeline they will have. But in general, I would expect this entire process to take at least a year, at least for the implementation of all the things that they want to implement. So it could take up to a year, and definitely it is not going to happen in 2023 for sure.
Yeah. So, Mr. Parvathaneni, can we talk a little, finally, we just have another 5 minutes, but yes, can we wind up on this? And finally, what are your thoughts? And finally, anything that you want to say? Because, when I'm looking in different social media sites, people are actually getting scared. First of all, there are a large number of Indians that have, that are moving continuously to USA on these work visas. And of course, most of them have lost their hopes about getting their green cards, because now it's like a really long process. So you see, there is a lot of scared people are actually scared for their future there in USA. And again, there is continuous motion from here to there. So anything that you want to say to the viewers who are getting worried, especially in this scenario?
Sure. I think the last couple of months, there's a lot of talk about recession and a lot of job layoffs in US. And that is concerning because the H1B employees, if there is a layoff, there's a termination. Unfortunately, they have to maintain the terms of their H1B visa. And what that means is it will complicate everything. The employees' children, they might be in the middle of the school year. And if somebody loses a job, there are a lot of rules they have to follow, and what that means is they have to find a new job. Otherwise they have to leave the country. So there is a lot of confusion and all those things. But the reality and the good news is the layoffs don't seem to be impacting people who are experienced. So people who are experienced, even if they're laid off, they're finding jobs pretty quickly. So IT sector, the news looks like it is impacted. Looks like there are a lot of layoffs. But the good news is there is also a lot of work, a lot of shortage of skilled IT employees in US. And the reason I say that is because I see a layoff and then I see people getting a new job, because we do file a lot of H1B transfers. Somebody lost a job, they're within their grace period, they find a new job. And it's not like 2008 or only 2002, 2001, where I saw when people were not able to get a job at all. So right now, even if somebody loses a job, it looks like there are enough openings in IT sector. There are still a lot of demand. So people are finding jobs easily. So so the good news is people don't really have to panic from a H1B visa perspective. And even in terms of approvals, in terms of the approval rate, because USCIS publishes the statistics, the approval rate is very high. And even for visa interviews, H1B visas back in India, at the consulates, they still have Dropbox. And what that means is if somebody has a US visa in the past, they're eligible for Dropbox. A Dropbox is a lot more simpler than an interview, it's a lot more quicker. So overall, the visa stampings in India seem to be smooth. The approvals in US seem to be smooth. Yes, there is a little layoffs happening here and there, but in the end, the market is still very tight. The IT market is not where experienced people are jobless. Experienced people are still finding jobs pretty quickly. And from what that means is, as long as people are working here, you're working and complying with the law, making sure all the H1B regulations are met, people should not have any issue. The only challenge we saw in the last 1 year is typically with the multiple registration issue, because people misused the lottery. It was only $10 for each lottery filing. So people, I think the USC has made it too easy for people to misuse the system, unfortunately. And a lot of people filed the multiple registrations because it was only $10, and USCIS was not asking a whole lot on the registration website. So people, I think, misused this lottery system. So the lottery system was one thing that I think failed, at least the electronic registration process. And I think USCIS has realized that mistake. They're trying to fix the problem. And overall, the advice for all the viewers is, anybody is on H1B visa in US, nothing to worry. Things are smooth. Approvals are good. Job market is not as bad, especially for the experienced people. Maybe for somebody who's fresh out of college, getting into their first job, maybe market is a little bit tight. But for anybody that is experienced, there is still a lot of demand, still a lot of vacancies, and things are smooth. Only thing is, people should know the H1B regulations, always comply with the law at all times.
Yes. I think that is it for today, Mr. Parvathaneni. We did have a great show. I think we did cover and answer a lot of queries that the people, were asking online. But again, thank you, Parvathaneni Garu, for tuning in and giving us your valuable time. Thank you again for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.